everyone, we are back. Camera's on. Before we start, is there any questions you have regarding the previous chapter? Let me know now in the chat. Questions? Nina, no questions. Felix, there's Felix, no questions. He's not even there. All right, since there's no questions, we're going to move forward. This is a very small chapter of 8 pages. We already talked about contract law in chapter 10. Then we talked about contracts for real estate in chapter 12 or 13. But we talked about two different chapters for contracts. Now we have contracts in New Jersey. Now, obviously, the difference is not much. So again, we're using New Jersey portion as partly review and then to point out a few things. Now, what contracts can we prepare? That's one of the questions that's always brought up. What contracts can we prepare? We could prepare contracts in New Jersey, and a lot of states have a very similar law to this. In New Jersey, we can prepare sales contracts or leases on 1 to 4 family homes and single building lots. Why? Because these are standard contracts. They are in pre-printed forms. So the Real Estate Commission decided that 1 to 4 families, they're pretty much the most common transactions out there. They figure out, being the most common transactions, they figure out what are the most common elements in those contracts, and boom, created a pre-printed form where we fill in the blanks, okay? We are not allowed to prepare commercial leases, option agreements, or sales contracts for commercial industrial property or tracts of open land, okay? So we're allowed to prepare contracts only for 1 to 4 family and single building or single vacant lots, right? So starting right there. Now, the second question would be, can we still be involved in commercial contracts? Can we still be involved in industrial contracts? And the answer is yes. We can still get paid for the transaction. We just don't draft the contract. You understand? So what we prepare is called an LOI, letter of intent, for those types of contracts. The pre-printed forms, they are established uniformly around throughout the state. The pre-printed forms allow us to fill in the blanks and make some minor modifications according to our understanding of that particular topic. It's not legal opinions, but it's our understanding of that particular topic, simply what applies or what doesn't apply. Like, for instance, if a property is in an area where there's a no private well, right? So we will put a checkbox where there's no well and cross out what doesn't apply to that particular property. Does that make sense? The Well Testing Act does not apply to that particular property. So these modifications should be initialed by both parties, and it is important to note that any handwritten changes overrule what's in the pre-printed form. So this book is pre-printed. Anything that I type into it overrides whatever's pre-printed, and anything that I write on it overrides whatever is typed as well. Okay. No, we cannot draft, Nina. We cannot draft contracts for option agreements, even if it's for 1 to 4 family, because an option is not a standard contract. That's the issue. An option agreement is an agreement between the seller and the buyer for a future sale. So it's not a standard thing. It's not a normal thing. So can we prepare contracts on 1 to 4 families if it's a contract sale or rental? Yes, those are straightforward. Nothing complicated. An option agreement has to include additional clauses that will protect both the seller and the buyer. Do you understand? So that's where the issue is. Are we practicing law? Or are we practicing real estate. You understand? So anything that gets complicated, that's out of the norm, we don't prepare. Delivery of copies. So delivery of copies says before a listing agreement, sales contract, or lease is signed, the licensee must create multiple originals of the document. So we have to have duplicate originals, right? And when you see the word duplicate, you think, well, duplicate is copies. Yes. Duplicate originals means if there's 10 people signing, we need to have 10 empty contracts for 10 people to sign each one of them. So there's 10 wet signatures on every single contract. Does that make sense? This way you get your copy, was signed by everybody. I get my copy signed by everybody. It's not one that's being signed and distributed to everyone. No. 10 individual signatures in 10 different contracts. If there's a change to a contract later on, then every single party must also address those changes by putting initials or signing. How long do we need to keep the documents? Retention. How long do we need to keep them? Well, we are required as a brokerage, we are required to keep unaccepted offers for 6 months. Okay? Unaccepted offers we have to keep for 6 months. So guys, my question to you is very simple. How long do we need to keep the offers? How long do we need to keep the offers? Let me know in the chat. How long do we need to keep the offers? If you're on YouTube, write the answer as well. How long do we need to keep the offers? How long do we need to keep the offers? Paying attention to the question is key. How long do we need to keep the offers? How long do we need to keep the offers? I see your answer, Ruth. Okay, let's figure out the answer. Ready? My question was, how long do you need to keep the offers? My question addresses all offers. If I said the offers, it addresses all offers. Is there a standard that we need to keep all offers? The answer is no. Because if the offers were unaccepted, not accepted as some of you wrote it, okay? It's unaccepted, meaning the seller did not accept your offer, did not accept the offer. If they're unaccepted, you must keep them for 6 months. Unaccepted offers. It's not all offers. It's unaccepted offers we keep for 6 months. But if the offers were accepted, they became contracts. And if they became contracts, you now keep them for 6 years. So anything that's a permanent record, listing agreements, sales contracts, financial records of such as banking records, payment for services, or whatever. So anything that's permanent records, 6 years. This is New Jersey law. Some states have three years, some states have 5 years. New Jersey says you got to keep it for 6 years if it's a permanent record. An unaccepted offer is not a permanent record. We got to keep them for 6 months in case of discrimination lawsuits, right? But that's it. Permanent records, 6 years. Again, Paying attention to the questions is key. There's things that enable certain answers. Okay? Unaccepted offers, you got to keep them for 6 months. Accepted offers became contracts. You keep them for 6 years. Permanent records. Okay, and of course, you got to keep all records available for inspection upon commission request. Statute of limitations. Why do we need to keep it for 6 years? Because there's something called SOL. You guys know what SOL means, right? Statute of limitations. Some of you are laughing. The SOL in New Jersey is 6 years. That means that somebody can sue you for up to 6 years after the transaction has concluded. And that's why permanent records we have to keep for 6 years. If you're trying to recover a property, if you're trying to recover, get it back because you were wronged in the transaction, let's say, then you have up to 10 years to recover your property. 10 years. If you take longer than 6 years to sue, guess what? You're SOL. Statute out of limitation. That's it. Dual contracts. So dual contracts in New Jersey are illegal. What is a dual contract? Well, it's two contracts. Simple. Everybody knows that. Dual contract, there's two contracts. But in dual contracts is having two separate agreements regarding the same property in the same transaction. So what we're saying is, Elda, I'm the seller, you're the buyer, okay? But we made an agreement where I'm selling the house and you're buying my house, right? So it's the same transaction, same seller, same buyer. But here's the thing. We need two contracts. I'm selling it to you for $300,000, but we're going to make a separate contract for $350,000. Okay? I'm selling it to you for $300,000, but we're going to make a separate contract for $350,000. What is that for? So I can make more money. So I can collect more money. In the state of New Jersey, that's illegal. If you sell for $300,000, then that's the sales price. You cannot have a separate contract for higher amounts. We cannot have that. Okay? So dual contracts are against the law, and in New Jersey can result in the license being suspended or revoked, and the licensee being fined and or imprisoned for up to 3 years. So cannot have dual contracts. The price is the price, period. Plain language requirements. So another thing we have in New Jersey, we're not required to have an attorney. We're not required to do attorney. We're required to have a period of time for attorney review, but we're not required to have an attorney. Meaning, Elda, I'm selling it to you, and you're agreeing to buy from me, and that's it. We agree to the terms. We're adults. We understand the terms of our contract, right? So, do we need an attorney? Technically, no, right? So, therefore, every contract must be in plain English, meaning everything has to be common, everyday language where it's clear for me, it's clear for you, and we understand everything. We're going to move forward, right? Can we still present this to attorneys to review? Sure, if we want to. I can have an attorney, and if we don't want to have an attorney, it's totally fine. You can have an attorney. If I don't want to have an attorney, it's totally fine. All right? So, plain language requirement. Everything in plain, easy, clear, understandable English. No fee schedule. You guys already know this. The commissions in New Jersey are 6%, right? That's the standard. Everybody knows this, right? No? No, of course not. In New Jersey, commissions are negotiable. In fact, when we sit down with the seller, the listing agreement comes up with a statement that says, as a seller, you have the right to reach your individual agreements. There's nothing set in stone in the law or by any governmental agency that says it has to be this percentage. You can choose whatever you want. What is acceptable, as we went over the other day, what is acceptable, what is common, what people got used to is the 6%. Or nowadays, 5%. Right? That's the, hey, I get it. I will not argue type of percentage. Right? Can you charge more? Can you charge less? That's totally up to you and your negotiation skills. That's how you value yourself. That's pretty much what it is. Okay? If you think you're worth 10%, go for it. Doesn't mean you're going to walk away with 10%, but you can start your negotiations at 10%. If you land on 7 or 8 because you're that good and they were sold on the fact that you're that good, then you're always above the average. Mr. or Mrs. Seller, if you want an average realtor, go ahead. They'll give you a 4%, 5%, go ahead. Now, if you want to conclude this sale tomorrow, and of course, I'm exaggerating, if you want to conclude this sale tomorrow, then I'm your guy or gal, right? This is what I'm going to do. This is my process. Why am I worth more? Because I do this, this, and that. Other agencies, they might not, right? So show what's the difference between you and everybody else. Anyway, next, you guys already know that we can prepare contracts on 1 to 4 family. For more than that or something that's unusual, we prepare the letter of intent, which is simply, hey, my client intends to buy your house for X amount of dollars. Are you okay with that? If you say yes, then we send it to our attorneys and they draft the agreement between them. That's it. So LOI is what we do. All right, a contract may be rescinded or canceled. We keep on repeating these words, right? Rescinded or canceled under any of the following conditions. False representations, obviously. If you said it was one thing and it's actually another, right? Now that I found out, I can cancel the contract. That's an obvious one. If it's based on out-of-state property or planned real estate development, we have to include 7 calendar day notice to cancel the contract. If it's a 1 to 4 family, it must have a 3 business day notice for attorney review and cancel the contract if no dispute is started within the 3 business days. A buyer may cancel or rescind the contract by sending written cancellation notice to the seller within 5 business days from the date the seller and the buyer execute the contract. And the homeowner who changes his mind about refinancing only, we talked about this in chapter 17 as well, refinancing only, can cancel a contract within 3, it's also business days of signing it. Refinances only. If it's towards a loan, purchase does not have the right to cancel the loan. If it's refinance, you have the right to cancel the loan within 3, again, business days of signing it. Okay. Next thing we have, it says while oral contracts can be enforceable in New Jersey, the New Jersey Statute of Frauds requires that certain contracts be in writing. So New Jersey says oral contracts, as of 1996, says oral contracts could be enforceable, right? But they also say certain contracts must be in writing. So which contracts must be in writing? Some real estate contracts, like the contracts for real estate transactions, in this case, sales. Real estate brokers' commission agreements. Leases for longer than 3 years. And we're going to stop right there. So when we were in the national portion of this book, we talked about leases for longer than 1 year must be in writing. New Jersey says 1 year, no problem, 2 years, no problem. But if it's 3 years or longer, now we consider this a long-term contract, therefore must be in writing. So if you look at the state exam question or even the school exam question, it will say real estate sales must be in writing, or 3 years or longer must be in writing. These are the rules, must be in writing. Real estate sales must be in writing, and if it's for 3 years or longer, a lease for 3 years or longer must be in writing. Commission is common sense. You want to get paid, put it in writing. This one is like common sense. There's no ifs or buts about it. You want to get paid, put it in writing. Okay? Like I said, in 1996, statute of frauds was amended to allow oral contracts to be enforceable. And to be enforceable, there must be clear and convincing evidence. That means I have to have something that shows that your intention was to do this or to do that. So it has to be clear and convincing evidence. Again, if you want to have commission paid in lease or sale, must be in writing. Again, guys, I'm not going in too much detail because it's just an overview of contract law. We already went over this. Just a few little things that New Jersey has that other states don't have. This one is common everywhere. There must be a description of the property in the sale or rental. The sale or purchase price. How much are we buying for? The seller's agreement to sell and the buyer's agreement to buy. The type of deed and the grantor's agreement to convey. Convey means transfer, if you guys remember. Okay. Time and place, the transaction closing, and the signatures of the parties to the transaction. Now, in the contract, we might also include financing contingencies. Hey, I'm buying this house subject to FHA, subject to VA, subject to conventional loan. Like, if I get these loans, I'll buy. If I don't get the loan, I don't have to buy. So these are called financing contingencies, right? I might also include, hey, I'm putting $1,000 good faith deposit or earnest money deposit, means the same thing, right? Subject to evidence of title or title search, subject to property inspection and being favorable inspection, like I like what I see after the inspection, I still want to move forward. We have to include Megan's Law statement, we just talked about it. We have to include off-site conditions for new constructions, we just talked about it. It's that 5-day notice, right, to cancel. What the property is zoned for. Consumer information statements, they have to confirm at the contract, it's the cover page, have to confirm that I did receive the CIS prior to any of this, okay? And other related contingencies. You guys remember from environmental hazards, if the property was built prior to 1978, most likely it has lead-based paint in the building. And lead-based paint is dangerous, could lead to several brain problems and even potential cancer, right? So lead-based paint has become a big issue. Any property built before 1978 must come with a disclosure in the contract and a pamphlet, right? And they must give the buyers 10 days to have the property inspected for lead-based paint. If you guys remembered a few moments ago, we just talked about having 3 business days to cancel a contract, right? Well, when it comes to lead-based paint, we have to extend that with the inspection period and give you at least 10 days, and I'm not bound by any contract until the 10 days have passed. Okay, that means I have the right to inspect for lead-based paint. If I find lead-based paint, I can either choose to move forward or walk away. Right? This is regardless of that 3 business day right to attorney review. Okay. This notice to buyer and seller is the enforcement of the CIS. So if you guys remember, CIS is the Consumer Information Statement, which in New Jersey, it's a document that discloses the potential agency relationships. I can represent you as a seller's agent, buyer's agent, disclosure agent, or as a transaction broker. The notice to buyer or seller is the cover page of the contract that says, hey, I intended to represent you this way. I'm now representing you this way. So the notice to buyer and seller is literally, again, the cover page of the contract that says, I represent the seller as a seller's agent, or I represent the buyer as a buyer's agent, or I represent both, or I don't represent neither. You guys understand? So now it's saying, what type of representation do we have? That's what the notice to buyer and seller does. All right, Nina. If a buyer finds out that the property having lead-based paint, do they have to inform the seller that there's lead present? Do they have to inform the seller? So the reports have to be made known to the sellers. Yes. So if I do an inspection, whatever comes from the inspection will be given to the seller. And again, because you are beyond the period of time or within the period of time, you have to have some type of reason why you're walking away. So yes, you have to present why you're walking away or why you're negotiating the value after contract. Okay. So yes. Speaking of which, binding contract statement. Every single sales contract and lease have to have a statement right at the beginning of the contract that says, this is a legally binding contract that will become final within 3 business days. Now, within 3 business days, you have the right to attorney review. So you can bring this contract to an attorney that must initiate the review within the 3 business days. If the attorney review starts after the 3rd business day, hey, I'm sorry, it's binding. There's nothing you can do now. That's the contract. This is what we're going to do. All right? So when must the attorney review initiate a dispute? Within that 3 business day period. So they'll study the contract and they start counting the time from the moment that there's a delivery of the signed contract to both the buyer and seller. The 3 business days start from when I receive a copy of that contract. So I put an offer, my signature is there. And you call me and say, hey Bruno, seller accepted. Oh, great. Did we start the attorney review? No, because I did not see that signature. So my signature is present, sign it and give it back to me. The moment I receive the signed copy, now there's 2 signatures present. We're both aware of the terms and what was the agreement, and starts the 3 business days, okay? Now, during those 3 business days, we're going to issue notice of disapprovals. Hey, line 109, change it. Line 915, cross it out. You see what I'm saying? So add this, remove that. That all starts within the 3 business days. Or simply saying, hey, you know what? We're walking away. Within the 3 business days, no harm, no foul. Okay? Within the 3 business days, no harm, no foul. I don't need to have an excuse to just walk away. Okay? Within the 3 business days. After the 3rd business day, there has to be some type of legal reason of why you're walking away. All right. Nina is still stuck in the lead-based paint, so let's go there real quick. The question is, what if you decide not to purchase? Does the seller have to disclose the fact that there's lead on the property from that moment on? Or can they act like they do not know? I think you're answering that question to yourself already. If you know something, first of all, that was federal law. We talked about it. So if the seller knows about lead-based paint, they have to disclose. Second, if they know and they're hiding, we just talked about it in the previous chapter. It's latent defect. A latent or hidden defect, right, must be made known, or the seller could be liable for damages in the future. Yep. Got it? Okay. Just saying. I think the book knows when you ask questions. I think the book knows what the answer is. So, see, both in the sale and the rental, every property goes with an implied warranty of habitability. That means if I'm buying a house, I expect to live in it, unless it's something that we sold as is. And even as is, if it's something that's structural, like I move in, I know I have to, like you're telling me as is because you're telling me, hey, roof needs to be replaced, there's mold that needs to be fixed, there's walls that need to be removed or added or whatever. The structure has this problem, so it's as is. Okay? And I understand. But if it's something that's hidden that I cannot see, then the as is does not apply. You understand? You cannot just say, hey, here's this phone as is. Take it. Now, if I know that the phone doesn't even work, right? If I know the phone doesn't even work or will crash tomorrow, right? Then the as is does not apply. This is very similar to the Lemon Law for cars. So when you buy a car, there's like a 6-month period. Even if they say the warranty is 30 days, BS. There's a 6-month period. If this car stops working within the 6 months, and I can prove that you knew about it, there was an issue that was already present, I can come and sue you, right? The as is assumes that I can use the property or I'm fully aware of the issues with the property, okay? And I'm buying knowing the issues of the property. You guys understand? Thumbs up on this? Great. That's why you should never waive inspections, even in an as-is property. Now, if you intend to if you intend to knock down the house, knock down everything, then the only inspection you should be looking for is if there's a oil tank or anything like that. That's it, right? Because you're going to look for the ground contamination, right? If you expect to knock down the house already, then hey, what are you going to complain about? A leak in the roof? You're going to knock down the house anyway, right? But if you expect to just, again, replace a wall, some plumbing, there's mold to be, like, I'm aware of that now. I'll buy it, I'll fix it, but if there's anything that was not disclosed, I can still sue you. That's the bottom line. All right, listing agreements. When we're dealing with listing agreements, obviously we're dealing with sellers. We already went over all of these. It's the same thing in New Jersey. When you're preparing a listing, you have to disclose the type of agency relationship. We just talked about it. Whether you're going to be a seller's agent or you're going to be a transaction broker, very, very important, or potential dual agency in the future. Now, there's 3 different types of listings that are allowed in New Jersey. And we also covered this in a different chapter. There's the exclusive right to sell, and there's the exclusive agency. As the name says, exclusive means one. And then there's the open listing, which means anyone, right? So what's the difference between these 3? In an exclusive right to sell, if you guys remember, in the exclusive right to sell, I'm working with one agency only. So let's say RE/MAX. And RE/MAX is listing my property. But if I, the seller, find, let's say I went to Quiznos and I was talking to Mr. Badur and I go like, listen, I like the way you prepare these sandwiches. Would you like to buy my house? Right? Let's say random conversation. And that's what we wind up with. He's buying my house, right? I think it was something similar to that, how you got, not with me, but how you got to this class. It was something similar to that. Completely out of the blue. By the way, what do you think about real estate? Right? He's nodding his head, so yeah. So imagine that's what it is. And all of a sudden, he's buying my house. In an exclusive right to sell, RE/MAX still gets paid because they're the exclusive right to sell agency. Even though I'm the one that found the buyer while I was eating, okay? In an exclusive agency, RE/MAX does not get paid because I found the buyer. I know it's RE/MAX that was listing, but I found the buyer. You guys understand? So in these 2, exclusive right to sell, no matter who sells the property or who finds the buyer, RE/MAX still gets paid a commission. In this one, whoever finds the buyer, it's either RE/MAX or me. And in this one, Could be Remax, Century 21, it could be Wycard, it could be New Direction Realty, it could be me, it could be whoever. It's open. There's an open relationship going on here. Whoever shows up with the buyer gets paid. Simple as that, right? So there's no exclusivity. There's no one agency advertising your property. There's a bunch of agencies advertising the property. Okay, you guys remember this? Great. Listing terms, obviously the listing has to have something called beginning and an end, right? Because except in an open listing. But in an exclusive agency or exclusive right to sell, I'm telling you, hey, I'm going to list with you for 6 months, starting today and ending in a particular day 6 months from now. So let's say it's April 27th, right? April 27th, it ends this listing agreement, period. Beyond that, it expires or we renew before that. That's simple. It has to be there. The list price must be there, and very important, compensation. Every listing agreement must stipulate how much you're going to get paid in a transaction. Is it going to be a flat fee, $18,000, let's say, or is it going to be a percentage, 6%, let's say. But it has to clearly state upfront how much you're going to get paid. The authorization for you to cooperate with other brokers, authorization to put on the MLS, and which MLS you're going to use, and then other provisions like signage, open houses, all that stuff. Again, all listing agreements must include expiration date. Must include expiration date. All listing agreements must include a commission notice, which by now we know again that it's negotiable, and they must explain that they have the right to negotiate that fee. In the listing agreement must also include an acknowledgement that the seller received the CIS. When must we provide the CIS? When did the seller receive the CIS? Let me know in the chat. CIS, when did the seller receive the CIS? Exactly, at first contact, absolutely. Hey, I want to sell the house. Okay, whoa. Before you sell the house, before you talk anything, say anything else, New Jersey requires me to disclose some stuff. CIS. Okay, as a seller's agent, here's what you can expect. Anything I find from the buyer, I will let you know. As a transaction broker, I'll do everything in my power to help the transaction conclude, but I don't represent you specifically. As a dual agent, I might represent both parties, but I will not pull more to one side or another, right? So upfront with the clients or customers. A statement of what your relationship now is. Am I representing you as a sales agent or am I a transaction broker? So it has to be in the listing agreement. And the copy of the Attorney General Memorandum of Law Against Discrimination, which says, seller, we cannot discriminate, but if you do, I'm liable as well, so I prefer not to work with you if you do discriminate. Pretty much, keep it simple. That's what we're saying. Do not discriminate. Obviously, everybody should sign. And we do have standard forms for listings, just like we have standard forms for contracts, right? That is it. And, oh, net listing, real quick. Net listing is illegal in New Jersey. You guys already know this. Most states outlaw net listing. And what is a net listing? Besides being illegal, net listing is the seller says, hey, I want $200,000 for my house. This is net to the seller. And you tell the seller, I think I can get you that. But anything above is commission. That's what you're saying. This is your bottom line, seller. I'll get you the $200,000, but anything above is my commission. Is that okay? And if the seller says okay, and the house sells for $400,000, that's the sales price, you just made $200,000 commission. I mean, that's great. To my pocket, to my happiness, to my life is great. But was that in the seller's best interest? Look, this question is a question we got to ask every single seller. How much do you want in your pocket? How much are you looking for? Because we got to know the realistic number, right? Because the way I do my math is, okay, you need 200,000. Closing costs more or less. Let's put another 20,000 on top, so that's 220. My commission is going to be roughly $30,000. So let's say 250. Property is worth 300. Okay. So, Mr. Seller, property is worth 300. I think you'll still walk away with another 50,000 on top. Does that make sense? Our job in New Jersey, we are a performance-based state. What does that mean? If it sells for 300, we get a percentage of the 300. If it sells for 400, our commission is a percentage of the 400. All right? We don't take net. We don't take net. We don't take anything above. That's illegal. That's not in the seller's best interest. Our job is to market the property so well that it sells for the highest probable price. And we get paid, we get compensated for getting the highest probable price. You guys get it? Thumbs up? Great. Awesome. With that being said, I told you this was a short chapter. We are done with chapter 28. Let me know if you have any questions before we end. Before I kick you guys out for your lunch at Quiznos. Questions? YouTube questions, Zoom questions, anywhere questions. Right? Oh yeah, there's way more. All right, guys, if there's no questions, and Nina, don't you dare. Okay? If you didn't ask a question until now, that's it. You're barred. If there's no questions, guys, then I wish you an amazing rest of your day. If you're going to join me in tonight's class, we have chapter 4 and 5 at 5:30, okay? See you guys.